Hello, my name is J. Norman Stark. I'm an attorney at law and a registered architect. I want to talk to you today about real estate closings and closing protection letters, also known as CPLs. Most people have never heard of that, but when you're ready to buy real estate or sell real estate, you ought to become familiar with it. Your attorney can help you. The documents and provisions involving the offer to purchase, mortgage, and transfer of title to real estate, commonly called real property by attorneys, requires careful consideration and certain drafting and precautions necessary to protect the parties and their interests. One of these special provisions is called the CPL, or Closing Protection Letter. The process of closing it consists of a real estate transaction involving several important stages. First, it involves an escrow, whereby documents and loan funds are entrusted to an escrow officer, a third neutral party, who's going to conduct and prepare closing documents detailing the financial obligations of each party. At a closing, which is a meeting of all of the people, it's the final procedure in the real estate sales process where the sale, the loan funding, and the mortgage are completed by signing documents for recording and distribution of funds held by the escrow officer. This procedure is also known as closing of escrow. However, among the most important documents that a seller or a buyer should obtain is a closing protection letter. The CPL is a document issued by a title insurance underwriter ensuring loss resulting from the title company's errors, inadvertent or otherwise, from their negligence or fraud in closing performed by the escrow and title agents and the attorneys. It indemnifies you against the loss or damage arising from a breach of a certain fiduciary duty, a duty that at law owed by the closing agent to the parties of the transaction. This document, the CPL, is absolutely necessary because the agency or principal relationship between an underwriter and a policy issuing agent or approved attorney is limited to the issuance of a policy and does not extend only to escrow functions. Now, if that seems like a lot of gobbledygook and legal jargon, let me make it simple for you. Purchasers of real property are also advised to require the purchase of a title insurance policy, frequently called an ALTA policy, to protect the validity of the title or to provide you clear title unimpeded by liens, undisclosed easements, or other clouds upon the title to the property being purchased. Now, in the event that there's an internal revenue lien on the property, which may not always be disclosed, it is the duty of the escrow agent or the title agent to disclose that to the buyer at the time of purchase. And that must be disclosed on what they call the HUD-1 or HUD form. It's by the Housing and Urban Development. It's a matter of government requirement under the law. So now we talked about escrow. The close of escrow and the proper conclusion of the entire transaction requires prompt recording with the recorder of the county in which the property is located. And that's the duty of the escrow officer, so to show that title will pass from seller to buyer or buyer to seller, and then it only becomes effective upon recording. And the recording must be done within a day or two after the signing of the documents. Remember, folks, purchasers of real property must carefully evaluate all aspects of the proposed purchase to protect their rights and interests before signing on the dotted line. Thanks so much. Now, how is that?